CR1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CR23-0566, State of Arizona versus David Lee Jones. Council would remind you that we're recording and live streaming the argument, so please identify yourself and your clients at the beginning of your argument. Each side will have 20 minutes, but you're not obligated to use all that time. But appellant's counsel, if you'll watch the clock and reserve as much time as you desire for rebuttal. We also, please keep in mind, we've read the briefs, we've studied the record, and have discussed the case in conference with counsel for appellant. You may proceed.
Thank you, Your Honor. I'm thinking, maybe mistakenly, that the reason there's oral argument here is
Counsel,
because the state's request to...
Can you state your name?
Oh, I'm sorry. Michael Dew for appellant. Sorry about that. The court granted oral argument in this case because of the state's request to probably re-argue the Sulu-Kerr decision. I don't wish to do that. I think that's a wonderful decision, and any defense lawyer would be proud to own that. So unless there's any questions, I'd like to reserve my time for rebuttal.
I do have a question.
Yes, sir.
Is it your position that the judge had an obligation here to instruct on this justification occupied vehicle instruction, even if the defense counsel had objected to that instruction?
I don't think he did that here. That didn't happen.
No. You're saying he has an obligation to give the
Yes,
instruction?
in the absence of someone affirmatively waiving it, you're right. I mean, he didn't object to that instruction. I wouldn't be here if that were the case.
Okay, so the obligation, he would not have an obligation to give the instruction if the defense counsel had objected.
You're correct, sir.
So it seems to me that what you're saying is the trial judge's obligation is to make suggestions to defense counsel about what instructions to be given and let defense counsel decide. Is that your position?
Well, no, that's the problem here. I don't think trial judges, and I had the pleasure of being in front of you, sir, for a lot of years when you're down in Superior Court. I don't think trial judges want to be what they call activist. They don't want to sit there and go, you know, well, buddy, we've settled instructions, you do this, you do that's great, let's do it. Oh, by the way, I'm going to do a fundamental error review here. It's not the obligation of a trial court. I've never seen that, 48 years. What I have seen is, counsel, I'm not going to try your case for you. I'm not going to tell you what to do. You're on your own. I've never seen that. So to answer your question, in the case that Sulu-Kerr talked about, yes, I think the judge has a duty to look at that. But in the absence of a request, in the absence of an objection, he doesn't.
Help me understand what the word forcefully, where would you advise us to turn to determine what forcefully means?
Well, the same reason it was in the Sulu-Kerr opinion. I think I don't know if it was Judge Williams who pinned that. I think he did. Forceful conduct. And well, I can't find it in the opinion, but it is, I remember it was stated in there forcefully because the state objected that what is forceful. Entering a vehicle, flailing around and threatening somebody, I think is force.
Okay, but he didn't use force to enter the vehicle, correct?
Well,
The
he
window
stuck
was
his
open.
body through the defendant's version. He stuck his body through the window, started swinging at him, saying, bring it on, bring it on. If that's not force, I don't know what it is. It wasn't, hey, let's talk about this.
So you're saying, I'm reading between the lines here, you're saying, is it sort of a totality of the circumstances? It's what you're saying, is it your demeanor? Is it your voice, the words you're speaking together with your bodily movements?
Yes,
or
Your
is
Honor.
it's all of that?
Yes, sir.
Do you have any, should we turn to a dictionary to figure that out? Or should, because it's not defined, you agree it's not defined in the statute, correct?
It's not defined where?
In the statute.
No, it's not. Says the legislature did not define forcefully, had it intended to impose some heightened standard beyond physically attempting to access the interior of a vehicle and expel the occupant without the occupant's permission or acquiescence, it would have said so. I have no problem with that. I think that's great.
Is the evidence that the victim here was flailing around, could that also establish a basis for an instruction on defensive property?
It probably could. That I didn't think of because the 418 was just so much on point. It probably could do something like that.
Well, that's one of the concerns that I have is the justification statutes, there are a number of them, there are overlapping in many cases. What is the trial judge's obligation to go through all of the instructions and pick out ones that could potentially apply, or is it an obligation to just read them all and let the jury figure it out? What is the trial judge's obligation?
No, sir. I think the trial judge, as most trial judges do, look at what the primary and sole defense is for fundamental error review. This case wasn't defensive property. He was afraid for his life, and he was in a vehicle. That's his only defense. His only defense. If there are a number of defenses raised, I don't think a trial judge has any duty to pick and choose because you're not trying to win or do the case for the defendant. As I said earlier, counsel, I'm not going to try your case for you. But when it's the only defense that a guy has, and it's so on point with where he's at, then I think that's the justification that has to be given. He wasn't saying, well, he was trying to steal my gun or steal my purse or steal my car or steal my whatever. He was trying to hurt me.
Okay, but he did get a self-defense instruction, but you're saying
Yes,
he didn't
did.
get the right one.
And he got a self-defense instruction that basically said, you don't get self-defense if you provoked it. And one other thing, too, they also got an instruction that said, for defensive display of a firearm, you don't get to use that instruction either if you provoke it. So now the jury's been told twice that my guy was in the wrong, whatever he did, and there's no justification whatsoever. That's the problem here, and I think that's where it parallels Sulu Kerr.
In Sulu Kerr, the defendant stated that she believed she was the victim of a carjacking. She's in a stolen car, but she's not the one who stole it.
In Sulu Kerr,
So
yes.
she believes she was the victim of a carjacking, and
Yes.
that's really what the statute 13418 is meant to address, that type of situation.
Right.
And there's no indication here that Mr. Jones thought he was being carjacked.
No, he thought he was going to be killed.
So this is, well, where did he say that? He said, I thought he
He
was
said,
going to hit
I
me.
was in fear for my life. That was his testimony.
Well, he also, well, okay, he said, I thought he was going to hit me.
No, if you read the transcript, sir, I just read it again. I was in fear for my life. I mean, I noted that specifically. Whether or not that fear is reasonable, I don't know. But he said it.
But this is distinguishable from Sulu Kerr.
I'm sorry, sir, what?
This is distinguishable from Sulu Kerr because this is not a situation where there was an attempted carjacking or a belief of an attempted carjacking.
Well, I guess you can distinguish it on whatever basis you want, but I think the defense applies to anybody that's trying to enter a car and do you harm. It doesn't have to be a carjack. Maybe that would be a defensive property. But someone jumps into your car and tries to do something to you, you can react to that. You can defend yourself. I mean, this Arizona legislature has pretty much given these defenses to people to avoid this kind of thing.
Counsel, another question about
Yes, sir.
the statute. It says the statute applies if the person was in the process of unlawfully or forcefully entering. Are you suggesting that it was unlawful in any way? I mean, and let me couch that with a hypothetical, or just a hypothetical. Say I'm parked at a gas station getting gas. Somebody comes up and I don't know why they would want to do this, but they reach into my vehicle. Is that lawful?
Well, it depends on what they're doing. Maybe you're drunk and passed out and they want to turn the ignition off, that kind of thing. Once you said earlier...
Just the idea, the act of inserting an arm or sticking your head in somebody's car is not
The act of insertion into a vehicle with the intent and the objective threat to hurt someone, yes, I think that's forceful entry. no if he's going to turn off the car because you're drunk, or no because you're trying to drive out of there without paying for gas, that kind of thing. That's different. I think that in the Sulu opinion they talked about that too. Unlawfulness of the aggressor's actions is not is. All it requires is forceful entry. Well, we're back to the thing with force again. And I think that once again what I read to you, that's forceful entry. Thank you.
Good morning, and may it please the court, Casey Ball, Assistant Attorney General, here on behalf of the state. I don't think the court needs to get into the definitions of the statute or what forcefully means or unlawfully means. Supreme Court precedent controls here. Sison v. State, State v. Lee, especially State v. Lee, Gendron, and Carson all hold.
Before we talk about those cases, then let me go back to forcefully. So the state essentially conceding that there was enough evidence to support a defensive vehicle jury instruction?
Yes, if he had asked for it, he would have been entitled to that, yeah.
All right, thank you.
The problem comes with where the duty lies. In State v. Lee, the defendant got up on the stand and said, I was acting in self-defense. It was a mutual combat situation, and then never requested a self-defense instruction. Yet, the Supreme Court held there was no duty on the trial court. In fact, the court said it's been well established in this state that the trial court has no duty to give a self-defense instruction absent a request from the defendant. As recently as 2018 in State v. Carson, the Supreme Court again emphasized that it is the defendant's duty to first demonstrate evidence supporting the instruction, and that he is entitled to a defense if requested. Although Sue occurred,
is it your position that this claim cannot be raised on direct appeal but could be raised in a post-conviction relief proceeding for ineffective assistance of counsel?
yes.
And so is it the case that the state would not then, in a post-conviction relief proceeding, claim that this issue was precluded because it should have been raised on direct
So
appeal?
I know that was raised in the reply brief, and we've talked with the county. That argument won't be made again in Stubbe. I'm familiar with Stubbe. It was my case on direct appeal. One thing that's not in the reply brief, though, is that the trial court then went on to address the merits of that claim and found it wasn't colorable. So although the court seemed to entertain the state's erroneous argument there, the court did ultimately find that there was no merit to the IAC claim. But yes, this is an IAC claim, if anything. And it needs to be in PCR because I don't know what defense counsel's thinking was. There may have been a strategic reason for not asking for it. It may have been an ethical reason. Or it may have been ineffective assistance. That needs to be produced at an evidentiary hearing where defense counsel can explain his reasons for not asking for it.
What other types of errors, if you can think off the top of your head, are you suggesting that cannot be raised on direct appeal? It seems like you're suggesting that this jury instruction realm is not subject to fundamental review, to Henderson, Escalante type review, and I wonder why. I wonder why you're suggesting that.
So because State v. Lee says it's not.
But State v. Lee's way before, State v. Lee's, isn't that from the 50s?
It is.
Yeah, but that's way before Henderson, Escalante, and I don't see a carve out in Henderson that says, oh, this only applies to this category of cases. It never applies to jury instructions that should have been requested.
So fundamental error is premised on the first step of there being error in the first place. The error alleged here and the error alleged in Sulu-Kerr is that the court had a duty on its own to instruct on this. If there's no error, we don't get into fundamental error or harmless error review. The question is there error on the part of the trial court to fail to instruct on its own?
So how would you deal with the Avila, State versus Avila, which is 1985, I think, that says in black and white there is an independent duty to instruct?
On issues that are vital to the defense. I would cite this court to...
But that was a case involving accomplice liability. Isn't that, this isn't vital to the defense here?
No, and in fact, in State v. Pulliam, it's a 1960 case just 4 years after State v. Lee, the Supreme Court distinguished between instructions on defenses and other types of instructions like elements of the offense, which were vital to the defense. The court, it was Pulliam, the site is 87 Arizona 216, the court there was faced with a failure to instruct on how the court should, or how the jury should consider the defendant's voluntariness of his confession. The court ultimately held that the court had a duty to instruct on the how the jury should instruct on the voluntariness of the confession. But it specifically said, we have a line of cases, it's well established that for defense theories, we don't have a duty to sua sponte instruct, but on this we do. Pulliam was later overruled about 15 years later when the Supreme Court said, yeah, you don't have a duty to instruct on how to consider the voluntariness of a confession. But the Supreme Court has very clearly carved out defense theories from things that are vital, like the U.S. Supreme Court has found that the state's burden of proof, the beyond a reasonable doubt standard, that's flows from the due process clause in Ray Winship is the case for that.
But how do
Elements of the
justification defenses tie into that? Because justification defenses put the burden of proof on the state.
If asserted by the defense, that's where we get to 13-205, and that's where the Connecticut case, Ebron, comes in. Connecticut has a very similar statute to 13-205 that requires the defendant to put forward the evidence of self-defense before the burden goes to the state. Now,
Put forth the evidence, but didn't that happen here?
it
He
did.
put forth the evidence.
Yes, but he didn't assert the defense, and that's what Connecticut says.
Okay.
If that statute is to mean anything, not only does the defendant have the burden of production, he has the burden to request the instruction as well. State v. Lee is still good law, although Sulu Kerr held otherwise. It didn't address any of these Supreme Court cases flowing from 1914 to 2018. This panel is not bound by Sulu Kerr. It is bound by State v. Lee, Blankenship, Pulliam, Gendron,
Avila.
Carson.
Avila,
But the difference there is Avila is not a justification defense, although there is that line of cases, and I acknowledge in my brief.
Let me read to you Avila. Avila says, a trial court has a duty to instruct on the law relating to the facts of the case when the matter is vital to a proper consideration of the evidence, even if not requested by the defense, and failure to do so constitutes fundamental error.
Yes,
So we're bound by that as well.
yes, but the Supreme Court Arizona Supreme Court has specifically carved out defense theories from those that are vital.
but it didn't bother to even mention the Avila, that
It was
Avila case?
pre-Avila. It was pre-Avila, but then we've got Gendron, which is post-Avila, saying that we don't inject.
Gendron's so help me understand how Gendron's what we have here. So Gendron, as I understand it, correct me where I'm wrong, but Gendron you have a defendant convicted on 3 counts. The unlawful flight count is the only one that he alleged justification. The other 2 he specifically disclaimed at trial.
Yes.
But on appeal, those are the 2 counts. He says the court erred by not giving justification, but he specifically disclaimed those.
Well, to be clear, he didn't claim that. The Court of Appeals injected its own issue on appeal in Gendron and said, we find that this is error, just even though it wasn't argued. The Supreme Court then said, yeah, you don't inject new issues on appeal, Court of Appeals. So that was the issue in Gendron. And it found that the trial court had no duty under fundamental error review or any other type of review, as the quote from Gendron, to instruct on these justification defenses. To be sure, the defendant did discount those justification defenses, but this court had held that it didn't matter that he discounted it. It was a duty on the trial court to do so. Supreme Court said, no, that's not correct, and it wasn't an issue raised on appeal in the first place. Now, fast forward to Carson and Gibson as well, a 2011 case. That one's a lesser included case. The court there, over both parties' objections, instructed on the lesser includeds, and the Arizona Supreme Court specifically said, look, it's harmless because the evidence supported it, but the trial court should be loath to usurp the party's own strategy. Carson, again, multiple times emphasizes the defendant's burden of first highlighting evidence that supports a justification defense and then requesting it. Carson did request the justification defense and it was denied, so it's not completely on point, but the Supreme Court has consistently, from 1914 to 2018, emphasized that the defendant bears some responsibility in requesting these instructions. It is not the trial court's obligation to sift through the evidence looking for the slightest evidence that might support it. This one's a fairly obvious one where, yeah, if he had requested it, the evidence would have supported the instruction. He may not have won on that justification defense. But Sulu Kerr's holding, if it stands, applies to every case, the close call and the obvious one. For the obvious ones, there's already a remedy, post-conviction relief proceedings, where defense counsel can try and justify why they didn't request it. But it shouldn't be on the trial court to sift through that evidence looking for any of the 18 or 19 different justification defenses that might apply, hoping that it's not reversed on some technicality. The end result is that we're going to have either a really long jury instruction conference where the court explicitly asks, do you want this instruction? And tries to get a waiver on any that doesn't apply, or the prosecutor asks that they're all given so that there's no chance of a reversal, or the jury is presented with all of them and then left confused as to which one applies when defense counsel is not arguing it. Moving to the fundamental nature, assuming this court disagrees that Lee is controlling here and agrees that Suluker is correct on finding his error, it's hard to imagine how this could be a fundamental error when nobody raised this justification defense. It wasn't on defense counsel's radar. It wasn't argued in closing. So it's really hard to understand how that would be a fundamental error, something that goes to the heart of the defense or that takes away a right of defense. Defendant wasn't advocating here for a defense of an occupied vehicle.
What was defendant's defense?
Closing argument was a little hard to follow, but it was basically self-defense and defensive display. Defense counsel spent a lot of time in closing talking about his own altercations in a parking lot in a Circle K, but ultimately it was you can't believe the victim and the bystander. Their testimony changed slightly, and this was a case of self-defense. That was his defense.
But the prosecutor certainly took away some of his ability to, took away because it said there was no justification. They didn't even apply because he provoked.
Correct.
He was the provoker.
Because those were the instructions that were requested. It makes sense that the prosecutor was arguing against the instructions that were requested. Those were the ones that the defendant was presenting.
But as far as how it might have been different, then I'm not so sure.
Right, and again, that's where in PCR, defendant can put forward a case that not only did this fall below professional standards for defense counsel, but that it prejudiced his case under the Strickland factors. That's where this needs to go. One, to find out, was there a strategy behind it, or was it ineffective? Or two, if it was ineffective, was it prejudicial to his defense?
So is it the state's position that that's what essentially should have happened in Suluker as well?
Yes. And Suluker is up on petition for review right now. We're arguing that, one, it was wrongly decided on the error grounds. We also note that PCR is the proper avenue there. There are undecided issues in Suluker that if the court reverses, it may come back to address some other undecided issues in that case.
Is Suluker distinguishable from our case, or is it directly on point?
It's pretty much on point. I know there was some discussions about forcefully and unlawfully, and is the just reaching in or like halfway in maybe distinguishable from a carjacking. The presumptions in 13-419 probably take this in the same realm as Suluker. The presumption doesn't apply if the person has the right to be in the car is the language. So if the victim here was jumping in and trying to attack the defendant under his version of events, I don't think that would fit under the has the right to be in the car situation, or even the reaching into a car at a gas station. If you don't have the right to be there, that's kind of the line, I think. But again, even if this is indistinguishable from Suluker, it's the controlling case law here is the Supreme Court precedent. State v. Lee is directly on point on this. The defendant got up on the stand, said I was acting in self-defense, didn't ask for the instruction, and the court affirmed, finding that the court had no duty. If there is no duty, there is no error, and we don't get into the realm of harmless or fundamental or structural. Lee has never been overturned. It was affirmed in Blankenship in 1965. It was most recently cited in an unpublished decision in 2009 here in Arizona. Since then, we've got Gendron and Gibson and Carson.
I should know this, but I don't. But did Suluker address Lee?
No. Suluker did not address Sison, Lee, Gendron, or Carson.
Were those, really asking you to reach back, were those cases cited by the state in the appellate briefing here?
It's been a while since I've read it. I will note that in Suluker, we only got 5,000 words in 2 weeks, and it was simultaneous briefing. So it was a pretty truncated briefing addressing not only was it error, but was it fundamental. It was a pretty fact-intensive inquiry. So I don't know which, if any of those were cited in the briefing there. However, because it's controlling binding precedent, whether the state cited it, the court is still bound by State v. Lee.
Sure.
Unless this court has other questions, I think the last thing I'd want to note is defense counsel noted that judges don't want to be activist judges and that he's heard that I'm not going to try your case for you. That's why the ruling in Sulukur is wrong. Trial courts are not second chair to the defense. They don't try the case for defense counsel. They're not looking over their shoulder trying to discover additional defenses that the defendant may be entitled to. That the justification defense statutes allow for these defenses does not mean that they are required anytime the slightest evidence is presented to support it. The defendant still bears the burden of production here, both of the evidence to support it, the slightest evidence, it's not a huge burden of production, it's the slightest evidence, and the burden to request the instruction.
Where's the slightest evidence come from?
From 205. 13-205A.
Because Sulukur doesn't talk about slightest evidence.
No. And so in reading through Sulukur, it talks about, issues vital to the defense. It cites the Avila case and that line of cases about vital to the defense, and then just finds in paragraph, I think it's 30, it's error and it's fundamental without discussing where that duty or that slightest evidence somehow merges into being vital to the defense. In Sulukur, the evidence was really slight. On our petition for review, we're arguing it doesn't exist at all, that the victim here was at all forcefully entering. He was in front of the car. It was the brother that was opening the door. It was the merest of evidence that would have supported that instruction had it been requested. A little bit different from this case where the guy's halfway in the car. But the ruling in Sulukur is that the court has a duty, even when it's that slightest evidence, to sift through the entire record, while managing the courtroom, managing witnesses, observing the jury, everything else, and somehow is supposed to meet that expectation that slightest evidence supports this instruction, I therefore have to give it. One of the first cases I had to brief on appeal involved one line of testimony that led to a request for a self-defense instruction, where the witness messed up his timeline and said the gun was drawn by the victim first, and then immediately corrected and said, no, sorry, it was the defendant had the gun first. That led to pages and pages of argument about whether a self-defense instruction should be given. Assume a situation where defense counsel didn't catch it, trial court didn't catch it, but on appeal we see this and we say, is that the slightest evidence to support an instruction? We have the luxury on appeal of reading through a cold transcript and saying, yeah, that looks like it could support the slightest evidence to support the instruction. The trial court doesn't have that luxury to do so. It's on defense counsel to be paying attention to the evidence and then raise any defenses that he or she believes are the defendant is entitled to under the justification statutes. Unless the court has other questions, I can sit down. All right, we ask that the court affirm the convictions. Thank you. And that it be in a published decision departing from Sulukur. Thank you.
If every faux pas is supposed to go back to the trial court for a PCR, there's no such thing as fundamental error review on appeal.
Well, what about just the realm of, I think, opposing counsel is saying in the realm of jury instructions?
Especially jury instructions.
Especially justification.
Yes, sir, especially justification, especially jury instructions. Escalante, the only thing I'm relying on is Sulukur and Escalante here, and I've said it in my brief. Escalante, the Court of Appeals said, take it back to the trial court and do a PCR, and that was an instruction. And if you look at paragraphs 29 through 34 of the Escalante opinion, they talk about it. They say, no, we're not going to send that back. That was a justification instruction, and substantial evidence of guilt is not the standard for deciding prejudice. Secondly, we cannot divine the reasons for failure to request an instruction on appeal. The consequence the tactical reasons for remaining silent in the face of trial error do not preclude a finding of prejudice. Paragraph 34 of Escalante. I mean, I'm grateful to the state for talking to the Maricopa County attorney about my other case that I have up in front of you gentlemen. That was about the most absurd thing I'd ever seen. But that's not the first time I've seen it. Every single time now, and I don't do PCRs anymore, thank God, but every time I get one of these cases, I think I'm just going to start raising fundamental error on appeal, and then when the court says, no, go to a PCR, that clues in the PCR person, and vice versa. That's almost the position that we defense attorneys have been put in because of this conundrum of is everything a PCR, or is there some such thing as fundamental error on review? I know trial courts don't do it, that's what I was saying before. But you guys do it, and the Supreme Court does it upstairs. Where's the line? Well, I think Escalante said the line. Thank you.
Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We're adjourned.